I'm particularly grateful with the University Paris-Dauphine for having organized this seminar on the regulator and its judge. I think that there's an interesting relationship between the regulator and the judge. They are two independent bodies. Both of them are independent. So it's somehow comparing, to compare these two independencies. The judge is beginning to recognize the independence of regulators, also having a care of de facto independence, is recognizing, at least in Italy, the importance of financial independence and on the independence of the human resources. But also the regulator should be aware of the utility, of the usefulness of having an independent judicial review, because an independent judicial review can strengthen his position, can strengthen the authoritativeness of the regulator, can strengthen some very delicate and crucial regulatory decisions. I made a short case study history about the jurisprudence of the Italian Council of State, where I have the honor of being judge. And I have demonstrated that consultation, for example, is considered by the administrative judge in Italy to have a founding role for the transparency and for the legitimacy of the decision-making procedure of a regulatory authority. And also the case studies on tariffs demonstrate that the judge is becoming more and more aware that he has to analyze, but he has also to understand what the technical complexity of the regulation offers. And so he's using more and more a technical expertise, an expert appointed by the judge, and responding to the judge. We can say to the judge, please stop here. This is a very debatable question. Leave it to the authority. It is well done. Which conclusion can we take out from this presentation, not only for Italy, but for the regulators and for the judges all over the world? The decision of the regulator should be more and more evidence-based. Consultation is not an empty ritual. It has to fill an impact analysis. It has to bring a widely discretional decision into a fully evidence-based regulatory choice. Otherwise, we have an arbitrary choice, or even worse, a political choice. So the regulator should make more and more use of the whole better regulation toolkit, not only of consultation. What should the judge do? What are the challenges for the judge? The judge should be more aware that the legal questions, that the world is not only made of legal questions, that there is an external impact of his decisions, which impacts on the markets, on the consumers, on the society, on the growth and on the competitiveness of a country. The judge sometimes tends to forget that. So the final conclusion for both the regulator and the judge is that the relationship between these two independencies should not be seen as a contrast between two bodies superiorem non recognoscentes, two bodies that don't recognize anybody above them, but should be seen as an alignment between two bodies, two public bodies that have only one common goal, the interest of their country, of their citizens, of their economy.